Hi, so session 47 on liquidation under IBC, and today we are going to deal with transactions defrauding creditors under section 49, 50, etc. But before that, let's do a quick recap of what we have discussed in the previous session. In the previous session, we have discussed four things, that is section 45, 46, 47 and 48. 45 talks about avoidance of undervalued transaction. 46 talks about relevant period for which this undervalued transactions can be examined. 47 provides for application to be made by creditor, and 48 provides for orders to be made by adjudicatory authority in case of undervalued transactions. This is what we've understood in session number 46. Currently 47, we are going to understand transactions defrauding creditors and other transactions. So section 49 of the IBC, one of the very important provisions which classifies third category of avoidance transactions, and heading is transactions which are aimed at defrauding creditors. So this particular section, I have tried to place the section with a subsection so that you have clarity on how it is crafted. Where the corporate debtor has entered into an undervalued transaction as referred to in section 45 subsection 2. So primarily to qualify under 49 as a defrauding transaction, then the transaction should have first fallen under section 45. Then plus that it should follow, or it should satisfy two conditions which are given here. Now see where the cursor is moving. If it is a transaction falling under section 45, plus the adjudicatory authority is satisfied that such transaction was deliberately entered into by such corporate debtor for two reasons. Number one, keeping the assets of the corporate debtor beyond the reach of any person who is entitled to make a claim against a corporate debtor, or in order to adversely affect the interest of such a person in relation to the claim. See, it is not and. If you see the word conjunction between A and B, it is or. So it is not necessary that both conditions be met. Even if one of the conditions, either A or B, is met, then this is going to be a transaction under section 49. But only one important thing is it should, as a pre-qualification, be falling under section 45 as an undervalued transaction. If it is such a transaction which is aimed at defrauding the creditors, then the adjudicating authority shall make an order, and the order can be following ways. Number one, restoring the position as it existed before such transaction, as if the transaction had never happened. That is, the property will come back to the company and the third party will have to part with the property that he purchased as an undervalued transaction. 2. Protecting the interests of persons who are victims of such transaction. It is not only reversing the property, but also all incidental orders which will protect the interest of other parties involved who have interest in the transactions is very important. Like corporate debtor will get back the asset, and all other parties who made maybe a payment under good faith, their money should be kept back. And also financial creditors, operational creditors, whose claim is very important eventually in the liquidation or in CIRP. Their interest must also be protected by way of an order. So the order is a broader order. But there is a condition, provided that an order under this section shall not affect any interest in property which was acquired from a person other than the corporate debtor and was acquired in good faith. So if a third party bought any property from any other person not being a CD, then this section cannot be invoked against such person, provided if it is good faith. This good faith word is very important. Then part 2. shall not require any person who received a benefit from the transaction in good faith for value and without notice of the relevant circumstances to pay any sum unless he was a party to the transaction. So repeat, shall not require any person who received any benefit from transaction in good faith for value and without notice of the relevant circumstances. So if I have received some money out of this transaction without notice of the fact that there is something fishy, and if I was in good faith, then I can't be asked to return any sums by way of an order. So these are the two exceptions to the order. Let's move to next section, which is section 50. So moving on to section 50, which deals with extortionate transactions. Have you heard the word extortion? Extortion is, in common sense, in the world of crimes, it is holding somebody for a ransom and taking money by way of blackmailing the person. So, in the world of crimes, extortion is already what we know. But when it comes to economic offenses, especially under section 50 of the IBC, though the word extortionate is used, it is in a different context. Let's understand what that is. Where the CD has made a party to an extortionate credit transaction involving receipt of financial or operational debt during the period within 2 years preceding the insolvency commencement date, the liquidator or RP may make an application for avoidance of such transaction to adjudicating authority if the terms of such transaction required exorbitant payments to be made by the corporate debtor. Now see, there are two different dimensions to avoidable transactions. Number one is the undervalued transactions, where CD deserved a larger sum of money, but it only got a small amount of money. It's an undervalued transaction. On the other hand, where CD is making a payment, while making a payment, instead of a smaller amount, it is paying an exorbitant amount of money for a certain transaction. So in both the cases, ultimately the CD is getting affected, and because of the CD, the claimants are getting affected, and hence what money you have to receive, you shall receive a reasonable amount of money, and when you have to make a payment, you shall always make only a reasonable payment of money. You cannot pay more and you cannot receive less than what is expected. These two transactions have completely contrast views. In case of receipt of money, get what you have to. In case of payment of money, pay only that much what you have to, you can't pay more. The moment you pay more than a certain sum, deserving sum on account of a certain transaction, it falls under extortionate transactions. I'm sure we're clear. But the period of time to which these extortionate transactions can be applied is 2 years preceding the insolvency period. We cannot go beyond that period of time. However, what will be the circumstances under which it will be treated as extortionate? Those circumstances will be provided by the Insolvency and Bankruptcy Board of India. In our words, it is IBBI. So the moment we see an extortionate transaction, we must do something to avoid this transaction. Like in the case of other three types of transactions. What is that we do? We naturally move adjudicatory authority and we inform them that there is a certain transaction which is avoidable in nature. Please reverse this transaction and pass orders accordingly. So even for a extortionate transaction made under section 50, there is a section 51 that deals with the order to be passed by adjudicating authority. So under section 51, we are going to see what are such orders to be passed by adjudicating authority. If the adjudicating authority is convinced or satisfied that exorbitant payments were to be made by the corporate debtor, it shall by an order restore the position as it existed prior to such transaction. And therefore, now whatever excess payments of money that you made will become recoverable. Set aside the whole or any part of the debt created through the extortionate transaction. Modify the terms of the transaction to eliminate the extortionate portion. Require any person who is a party to repay any amount which he has received on account of extortionate transaction. And the last one is require any security interest to be relinquished in favor of RP or liquidator. These RP orders which can be passed by NCLT here as an adjudicating authority, plus also it can pass any other order which is deemed necessary. Now let's look at example for an extortionate transaction. Without this, probably we cannot really make sense as to what we are talking. So example is Bye Motors Limited borrowed loans from various bankers. The company was on the verge of defaults. The moment I am using default or the word verge of defaults, immediately it should strike to your mind that the next step is going to be a CIRP insolvency proceedings. And remember, whether you and I know it or not as professionals, the corporate debtor and its management will actually anticipate that this is the next step which is going to happen. And the moment they anticipate a CIRP application, their mischief will begin in different forms and shapes. And this is one of the forms that we're going to talk about now. So, when the company was on the verge of defaults, predicting CIRP, it borrowed fresh loan from a banker by name CDFI Last. This is a banker. This bank has agreed to give a loan, but the bank said, your monthly rate of interest could be 5% per month. If you are agreeable to this sum of money, I will lend you money, otherwise I will not. Now in a desperate scenario, you may agree to pay such amounts of interest and borrow. Let's quickly understand. On an average, in a good credit scenario, what is the rate of interest payable by the borrower? Let me tell you, in individual hand loans, when A lends to B certain amount of money, he might charge a monthly interest rate of 2%. But when a corporate is borrowing from a bank, the interest rate will be 14% per annum, which if you divide it and bring it to per month basis, per month interest rate can come to about 1% to 1.5% at the maximum. This is called as a reasonable interest rate if the borrower is credit worthy. But against an average of 1 to 1.5% rate of interest, if a certain banker is charging a whopping 5% from certain party, then what should happen? So the CD signed the loan documents agreeing to this kind of a interest rate from the company, from the banker. After borrowing this interest rate at 5% per month, insolvency petition was filed against the company within the next 6 months. Obviously, as predicted, insolvency has come. Now, you can easily understand from the example what I gave that the moment an RP or liquidator takes charge of this corporate debtor, the first thing that they will do is they will see the transactions that have happened in the past 2 years and primarily pick up this transaction and say this is one transaction in the nature of extortionate transaction because the average rate of interest paid is about 1.5% per month, and this particular banker is charging about 5% per month or something about 60% per annum. The moment he sees this interest rate, he will feel it is extortionate. Then what happens? The resolution professional will take this matter to the adjudicating authority and prove beyond the doubt of every person that this is an extortionate transaction, and the adjudicatory authority will pass an order in favor of the resolution professional and call this as an extortionate transaction. This is the trouble with these kind of avoidance transactions. Whatever smartness that a corporate debtor uses or its management uses any kind of a technique, end of the day, an experienced liquidator or a resolution professional who actually takes charge of the corporate debtor will instantly come to know the foul play done by the management and the corporate debtor and take them to task by reporting these transactions to adjudicating authority. Now I'm going to take you to a live case instead of an example. This case is Shinhan Bank versus Sungil India Private Limited. The adjudicating authority is NCLAT, not NCLT. That means this is a appellate jurisdiction. That is understandable. The facts of the case are as following. Messrs. Viva Metals and Alloys Private Limited, who is an operational creditor of Sungil India Private Limited, which is a corporate debtor, filed an application under Section 9 of IBC as an operational creditor initiating an action of CIRP. The application was admitted on 1st June 2018 and Mr. Rajesh Parakh was appointed as a resolution professional. Before the application for CIRP, these are two important facts for you to know, that there was a CIRP initiated, but before that what happened? That is what gives you an idea about extortionate transaction. The lenders lent short-term loans to the CD which failed to repay the short-term loans. The lenders then extended the loan period and charged an interest rate of 5% per month. Now you see what you can easily relate this to the example that we studied in the previous slides, and now the real life story which happened between Shinhan Bank and Sungil India Private Limited. So I just said that in the previous example that we studied and the live case that we are studying here, the cases are very similar. In this case, the lenders have lent loans to corporate debtor at a phenomenally high interest rate of 5% per month, and this was done just before the commencement of CIRP proceedings. Hence, the instant thought would be that RP will have to report these transactions. So let's see fact. Point number 5. What happened? The lenders have made a claim pursuant to a public notice by RP as if nothing had happened. They had made a claim that, boss, you've called for claims, I am making a claim. I have a principal amount to be received from the corporate debtor plus an interest rate of 5% is what they owe to me. The claim included principal amount plus interest at the rate of 5% per month. The RP, who will verify the claims that we have studied already, as soon as he verified the claims, he accepted the principal amount and he realized this is an extortionate interest rate and had completely rejected the amount owed on account of interest. So only the principal was accepted. When an application was made, this is an appeal, because remember, firstly, RP rejected your claim and rejected the interest amount. The moment RP rejected your interest amount, the first move you make is to NCLT saying that RP had done a mistake, please allow my entire claim. Now what NCLT did, when an application was made, adjudicatory authority rejected the whole amount of claim. That's very surprising. Usually this doesn't happen. But in this case, adjudicating authority, instead of sticking to the matter of interest, has gone one step beyond and said, boss, if you are charging extortionate interest on your principal amount, not only is your interest in doubt, but also your principal cannot be paid now. Therefore, the whole amount I am calling it as an illegal claim, and you will not be qualified to come here as a financial creditor. So this is a very serious grief to the creditor. Hence what they've done is they have now gone on an appeal to NCLAT against the decision of the NCLT that my claim should be admitted. You have no business to actually reduce my claim. What are the appellant's arguments? Appellant's arguments, the creditors who lent money, the time limit for avoidance transactions clearly expired. According to them, it is way past the time limit. 2. Adjudicating authority made a mistake of completely rejecting the claim. We can understand if you're calling interest rate is exorbitant or extortionate, but how can you completely ignore the principal amount that we've actually lent? That you cannot as illegal claim. These are the two vital, arguments from appellant side. Obviously, we don't have to listen to respondents. We'll have to look at the conclusion. The appellate tribunal, that is NCLAT, held that the transactions are absolutely extortionate within the meaning of section 50 of the Act. Forget about the time limit and the defense that you're claiming. It said the claimants shall be treated as unsecured creditors and may make their claims accordingly. And hence, you cannot be treated as financial creditor. You cannot claim that entire money in the order of preference under section 53, but you will stand at almost the bottom of the table as an unsecured creditor. After the operational creditor, you might get your money. So this is how extortionate transactions, which are trying to suck the blood of the corporate debtor, can be treated by NCLT. Hence, friends, I think at the end of all that we have understood about 4 kinds of avoidance transactions, what is the simple lesson that we should learn as a corporate debtor? The simple lesson is to be fair and transparent. Though you are anticipating a CIRP or a liquidation proceedings, you cannot act smart by entering into these avoidance transactions against the interest of the claimants. If you do, we will find out ways to avoid these transactions and make the situation better for the claimants and worse for the CD and also people who have done these avoidance transactions, right? So let's move to one more important concept. While as this is important, you would have realized that if there is PUFE transaction, preferential, undervalued, defrauding creditors or fraudulent transaction, lastly extortionate transactions. If you have these 4 transactions, RP cannot take an action by himself. RP has to report to AA and wait for the order of the AA. While you wait for the order of the AA, can liquidation be commenced? Can liquidation be concluded? Can dissolution be implemented? For this question, the answer comes from Regulation 44A of the IBBI liquidation process, Regulations 2016, which clearly says, yes, the liquidation can happen, yes, the dissolution can happen. However, the liquidator or the RP shall give one plan as to how Does he continue with the proceedings during and after liquidation? And what happens to the proceeds that are received from these cases with the adjudicating authority? How do you distribute these proceeds? If you have clarity on these two aspects, then you may please continue to liquidate and dissolve the company while PUFE transactions are pending proceedings in a adjudicatory authorities court. Right, so this brings us to the conclusion of this session. Quick summary, we have covered section 49, transactions that defraud creditors. I've already told you, remember, the pre-qualification for these transactions to qualify under 49 is that they should qualify as undervalued transactions. Only then they can come under 49. And then section 50 talks about extortionate transactions, and section 51 talks about orders in respect of extortionate transactions. We understood both of them with the help of respective case laws, and this is where we conclude all the 4 avoidance transactions. In the next session, we will get into core process of liquidation. We will see overview, and we will also maybe get into IBBI regulations. Just before I wrap up, one critical point, I have so far not covered any regulation except the regulation that you now see on the screen, which is regulation 44A. The rest of the regulations we will eventually cover through these sessions. That rests the session 47. Thank you so much.